Hello, beautiful, amazing people. I'm sorry, excuse me. I'm very happy to be back your way. Today, we're going to be discussing a great topic, the public charge rule of inadmissibility. Okay, public charge rule. So, if you're a green card applicant, you might want to watch this. I'm breaking down what the public charge rule means, the new final rule that was recently updated just this a few days ago, December 2022. So please stick with us and let's go through what this public charge means, who it applies to, which people are exempt, what types of benefits it covers, what types of benefits it does not cover, and just frequently asked questions about the public charge rule. Okay, so if you're watching us um, on YouTube and you haven't yet subscribed to our channel, please consider subscribing. We're the biggest legal community of immigrants in the United States. So join us and don't forget to share, you know, and yeah, react to our video if you're watching on any other channel as well. Of course, please follow us on all those social media channels, aka Poku Law, across our social media channels will come up once you search for us. I'm so sorry. Okay, so let's get started. Let me share my screen with you guys, and then we'll jump right into it. As you can see, I've highlighted certain portions that I would like to discuss with you. Okay, so this document was released by U.S.A, United Citizenship and Immigration Services, the federal agency that adjudicates affirmative immigration applications in the United States. So if you file a green card application known as an adjustment of status, if you're here in the U.S. as the beneficiary, then your application will most likely be reviewed by them. Okay, so um, on December 23rd, 2022, the public charge ground of inadmissibility final rule went into effect. This was a few days ago. So we're now working with this final rule. Why has this rule been updated? We'll look at the rationale behind the update of this rule. Okay, so the Biden administration is saying that they want to restore trust in our legal immigration system, and they have identified excessive or unjustified administrative or other barriers that impede access to immigration benefits and fair, efficient adjudication of these benefits. So, one of the things that triggered, the update of this rule, the public charge rule has been in existence for many years. Now, when Trump came into power, of course, as you guys know, he broadened the meaning of the public charge rule. Any type of benefit you took from the US government, it made you inadmissible under the public charge rule. So if you took even, Medicaid, or even more recently, the COVID vaccine, people were being deemed or were deemed inadmissible because of these things. And it was very scary and frightening because, as you guys know, for example, COVID is a public health issue, or is of public health concern. And so if certain people are undocumented or they were non-citizens and they needed to be protected against this virus, and for fear of never being granted a green card, they did not take these vaccines. These were the same people that you were going to meet in the grocery stores, at Walmart. You were going to meet them, at the gas stations and all of that. So it endangered the entire public. So, when Biden came in, he wanted to restore trust in the legal immigration system and to make America safe for everyone. Okay, so that's the rationale, because it was just very scary that certain things that were vital to the safety and the lives of people right here in the US, people were afraid to access those type of benefits based on the implications or the consequences of doing so. So it goes on to say that we must ensure that immigrants and their US citizens and non-US citizens family members are not deterred from obtaining access to important government services for which they are eligible to keep their families safe and healthy. So, for example, the WIC program, you see, there are undocumented people who don't have any immigration status who will give birth to US citizens, and they don't have good jobs. They don't even have jobs at all. Heck, like they don't even know how they're going to buy formula, right? There's the WIC program that's available for US citizen, babies. And so these undocumented people, were saying that, look, if I go take any of these benefits like Medicaid or, for my child or even for me, then I could be in trouble, you see. So these type of, punishing people for accessing public benefits, when they needed to access those benefits was not helpful to US citizens or even to the entire nation. Okay. So there you go. So, for example, we do not consider vaccines or public health benefits specifically related to COVID-19 pandemic. You can continue to receive the care you and your family need to protect your health and limit the spread of COVID-19. Yes. So, at some point, some people were being deemed inadmissible because they are taking the COVID-19 vaccine right here in the US, and they are taking free tests and all sorts of things. They were being prevented. They were not being allowed to, they were being prevented from coming into the US based on based on their access to these resources that they were entitled to, we could say, or was in our own interest to allow them to take. Okay, now let's move further down. Let me see. Oh, I think I need to just scroll here. Okay, I think this is it. Let's go to the second page. Okay, so now what are the key facts about the 2022 final rule? First of all, what is the public charge ground of inadmissibility? So, a non-citizen's application for a visa, admission or adjustment of status could be denied if they are found likely at any time to become a public charge. What does this mean? It just means that you are likely to become a public burden. You are likely to become a burden on the US government, on the US, on the taxpayer, on everyone in the US. You're just a public charge, a burden, right? So for DHS, Department of Homeland Security, a public charge inadmissibility determination is based on a non-citizen's likelihood of becoming primarily dependent on the government for subsistence, demonstrated in two ways, okay? In two ways. First of all, either by your receipt, you receiving public cash assistance for income maintenance. That's the first way in which you could become a public charge. Or number two, long-term institutionalization at government expense. So if you're going to be, admitted in a mental health institution or in a nursing home for a long time at government expense, then you are likely to be deemed a public charge, because all these things means that the government is going to be paying out of pocket for you, and you are just a burden on the government. Okay. And you see, again, please note that this applies to non-citizens. It does not apply to people who are already green card holders or US citizens. It applies to people who are non-citizens or aliens, as our Immigration Nationality Act refers to them. Okay. So I'm sorry, that was choking my neck. Yeah. Now we're going to be taking a look at how does USCIS administer the public charge ground of inadmissibility. So the next thing is, well, of course, as you guys know, applications that were submitted or that are submitted after December 23rd, 2022, they are going to apply the final rule. So any application that's submitted, any green card application submitted from today onwards, today is December 27th. So, of course, they're going to use this 2022 final rule. Okay. Now, some people are exempt, of course, as you guys know, in law, so many exemptions. Some people are exempt from the public charge ground of inadmissibility. We'll go through some of these people. The following non-citizens are exempt from the public charge ground of inadmissibility when applying for visas, admission, or adjustment of status. Okay. So we have asylees and refugees, people applying for asylum. Then American immigrants at admission, they are exempt. This means that the public charge rule will not apply to these people. Afghan and Iraqi interpreters or Afghan Iraqi nationals employed by on behalf of the US government, Cuban and Haitian entrants at adjustment of status, applicants seeking adjustment under the Cuban Adjustment Act. Okay, it's a very long list. We might not be able to go through everything, but here's a list right here. Haitians who are adjusting status to LPR, lawful permanent resident status, who are trying to get green cards. Okay. Then Lottenberg, parolees, special immigrant juveniles. These are abandoned, neglected, or abused children, normally under the age of 18, or sometimes 21, depending on the state in which they are based. These people are neglected by their parents and they're able to get I'm sorry. They're able to get green cards based on their on this abandonment or neglect or abuse. Okay. Applicants for registry, applicants seeking TPS, human trafficking victims qualifying, victims of qualifying criminal activities like the U immigrants, self-petitioners under the VAWA. So VAWA, people who are applying through VAWA, for green cards through the VAWA process. So, there's a long list: certain Syrian nationals, Polish and Hungarian parolees. So go through this, to make sure that if you want to check to see if the public charge rule applies or does not apply, so you can go through this list. Now, what are the factors that USCIS will consider when making a public charge admissibility determination? For all applicants for adjustment of status who are subject to the public charge ground of inadmissibility, USCIS must consider the statutory minimum factors of these things. They'll look at your age, health, they'll look at your family status, assets, resources, financial status, education, skills. Okay, so the bottom line is they'll look at the totality of these circumstances to see, are you likely to become a public charge? Are you likely to be someone who's going to be, likely to become a burden on the US government? Okay, so that's what they'll look at, all these factors, these statutory minimum factors. The applicant provides relevant information about these factors. Yes, once you're filling out the I-485, you're going to be providing a lot of information about your health, how much, what your financial status is, your education, your skills, and then they'll determine whether or not you're likely to become a public charge. USCIS will favorably consider sufficient AOS, that's the I-864 form, or the form I-864 EC, of course, if that's required. So they'll review your form I-864 to see also if you're likely to become a public charge or not. USCIS will also consider any current or past receipt of public cash assistance for income maintenance or long-term institutionalization as government expense. Okay, so they'll look at whether you've received past, current, or you're receiving public cash assistance for income maintenance. Okay, those are the things that make you a public charge or long-term institutionalization at government expense. Okay, now let's move on to the next page. We have a lot to cover, so we want to just make sure we're moving fast. So now we consider an applicant's current and or past receipt of public cash assistance for income maintenance. Public cash assistance for income maintenance includes only the following. They include only three things. The first one is supplemental security income, SSI, cash assistance under the TAN program, temporary assistance for needy families. And then the last thing is state and local cash assistance programs that provides benefits for income maintenance often called general assistance program. So they are going to be considering these things to determine whether or not you're a public charge. Okay. Now, we also consider an applicant's institutionalization for long-term care at government expense, such as in a nursing home or mental health institution. They'll look at these things to determine whether or not you're a public charge. Okay. So this is okay, so this is just a note. Please take note that it's very few applicants who are normally both subject to the public charge ground of inadmissibility and who are also going to be eligible for these public benefits before they get a green card or before prior to adjustment of status. What this means is that a lot of the times, many of the people who are subject to the public charge ground of inadmissibility are normally not even eligible for these public health benefits or these public benefits. Okay. A lot of the times, if you are undocumented, sometimes you may not be eligible for some of the benefits, or if you don't have a green card, because some of the benefits will require you to be either a U.S. citizen or a resident of a county or a state or whatever in order to be eligible. So it's just a note that sometimes, in fact, many, it's just a very, a very small number of applicants who are both subject to the public charge ground of inadmissibility, and at the same time they will be eligible for these public benefits before or prior to adjustment of status. Okay, so what are the public assistance programs that U.S.A does not consider to determine whether or not you're going to be a public charge? So we're going to look at the programs that do not form part of the public charge rule. So if you're taking, if you're part of these programs, then you shouldn't be too worried if you're applying for a green card. You shouldn't be afraid that you're going to be denied because you're part of these programs. These programs are not considered. For example, U.S.A does not consider any of the following benefits when making a public charge determination. Well, let me go up here again. We do not consider non-cash benefits in making public charge determinations. The only non-cash benefit we consider is long-term institutionalization at government expense. Okay. We also do not consider special purpose cash assistance that is not intended for income maintenance. Okay, so now the first one, nutrition programs, they are not considered. So for example, just look at something like WIC, which is very popular, special supplemental nutrition programs for women, infants, and children, WIC, and then SNAP or other nutrition programs not considered. School lunch and school breakfast programs are not considered. You see, so if you are, you are undocumented and you have, for some reason, you have children who are in schools and they're taking school lunch programs, school breakfast programs, you shouldn't be concerned that it's going to count against you. All these list of programs, and then health programs such as CHIP, Children's Health Insurance Program, health insurance through Affordable Care Act, Medicaid. Of course, there are always all these exceptions. So take a look at what you find on the screen. I hope the screen is quite visible to you guys. Hopefully, yes. Now, education and childcare programs also, like Head Start, if you're attending public school, they are not considered in public charge determination. So cash payments that are provided for childcare assistance or other supplemental special purpose cash assistance programs. Okay. Then disaster relief programs and benefits such as social security, retirement benefits, government pensions, veterans benefits, and unemployment insurance, not considered in making public charge determinations. Then other public benefits, job training programs, child tax credit, energy assistance, all these programs, transportation vouchers or other non-cash transportation services, those are not considered also. So you should not be too concerned about that. Okay. Okay, we'll skip this portion for now. Okay. Okay. Alrighty, let's go through some of these questions. Would that count? Let me see. I hope I didn't skip any part of the question. Oh, yeah, I think there's something at the bottom here. I cannot see it anymore. Let me see if I can pull it up on this screen. It looks like there is something I'm missing at the bottom of this page. This is page 8. Okay, let me jump straight to page 8 right here. Okay, so the question is, what if a family member living in the adjustment applicant's household uses public cash assistance for income maintenance or long-term institutionalization at government expense? Would that count against the applicant's immigration status or eligibility for immigration benefits? So, yeah, that's a very good question. If you have a family member who's using these things and then you, the applicant, you're not using these things, would that count against the applicant's eligibility for, let's say, a green card or, yeah, for immigration benefit? No. No, U.S.A says no, even if you have someone who's in your house who's receiving these public benefits. So let's look at the answer here. The receipt of public benefits by an applicant's family member is not considered in a public charge inadmissibility determination under the 2022 final rule. Only public cash assistance for income maintenance or long-term institutionalization at government expense provided to the applicant, where the applicant is listed as a named beneficiary, are considered in a public charge inadmissibility determination. Now, does the receipt of public benefits by someone who naturalized or derived U.S. citizenship affect their citizenship? No. Anyone who naturalized or derived U.S. citizenship, you cannot lose your citizenship because you've received public health benefits. So, your receipt of public health benefit is not does not affect someone who's naturalized. A naturalized person is someone who was not a born U.S. citizen but grew old and applied for U.S. citizenship through, the process of naturalization, or someone who derives citizenship from their parents, for instance. Okay, um, it will not affect your citizenship. Are lawful permanent residents subject to public charge inadmissibility when they apply to renew their green card? No. It only applies to you from the beginning if you're now trying to get a green card from the get-go. If you are renewing, so let's look at the answer. Renewing, it does not apply to you. No, lawful permanent residents applying to renew green cards are not subject to the public charge inadmissibility determination because they're not required to establish that they are admissible to the United States to renew the green card. Okay, so if you're renewing a green card, it does not include proving admissibility. Unlike if you're applying for a green card from the beginning, that one you're required to prove admissibility, that you are actually admissible. Okay. Does the receipt of public benefits by a lawful permanent resident affect their immigration status when they're while they're in the US? No. DHS only applies the public charge ground of inadmissibility to applicants for admission to the US or to applicants for adjustment of status who are already in the US. Lawful permanent residents have already adjusted their status. Okay, so the receipt of public benefits by a green card holder, it does not apply. It doesn't affect their immigration status. So if you're a green card holder already and you're here in the US and you receive it will not affect your green card holder status, or it will not affect your lawful permanent resident status. Okay. So you don't have to worry about that as well. What if an LPR status, a lawful permanent resident, has received or is receiving public cash assistance for income maintenance or long-term institutionalization at government expense, and they depart the US? Will they be subject to a public charge determination upon their return? No, you will not be subject to it. If you are an LPR, you've traveled, you're a green card holder, and you've received public, cash assistance for income maintenance, or you've been at, let's say, the mental health clinic for a long time at government expense. Maybe you had depression, you've been at an institution for maybe a long time, and you leave the US, you've traveled and you're coming back. Will you be subject to the public charge determination? No. except in a few unusual circumstances. Okay. DHS does not typically treat, if you are an LPR and you've been outside the US, you are not treated as an applicant for admission when you return from a trip abroad. So you will not generally undergo admissibility tests such as the public charge inadmissibility determination upon your return, unless of course some of the things apply. Like for example, you've been out of the US for a very long time, for more than 6 months. You've been absent, even if as a green card holder, you've departed the US and you've been gone for, let's say, 8 months. When you're coming back in, you're subject to the public charge rule, because you are now an applicant for admission. You need to prove that you didn't intend to abandon the US as your home and all of that. So these are some of the exceptions. And where you've abandoned or relinquished your status as an LPR, a green card holder, then you'll be subject to this rule. So generally, if you're a green card holder and you depart the US and you come on time, as you know, you as a green card holder, you should not stay out for more than 6 months at a time. Generally, if you're coming in after 3 months, you're fine. You're not subject to the public charge rule of admissibility or inadmissibility. Okay, so does the current and or past receipt of public benefits automatically result in an applicant being found likely at any time to be a public charge? No. U.S.A considers current and past receipt of public cash assistance for income maintenance and long-term socialization, taking into account the amount, duration, and recency of the receipt. Current and or past receipt of these benefits alone is not a sufficient basis to determine that an applicant is likely at any time to become a public charge. Okay. Yeah. Okay, so this question, is discussing the fact that if you've gotten any public benefits in the past or currently, does it automatically mean you're going to become a public charge? No, it doesn't mean that. It's always, remember, it's a totality of the circumstance. So the fact that you've received some of these things does not mean, or it's not sufficient basis alone. It's not a low. That alone is not sufficient basis to show that you are likely to become a public charge. Indeed, you could have received some of these benefits, but you could be determined not to be a public charge. So it's not dispositive, like the fact that you've received these benefits, these non-cash benefits or long-term socialization doesn't mean that automatically you are a public charge. Okay, so the past, current receipt and long-term institutionalization is only one factor they consider. They consider the totality of the circumstances. We discussed it, your age, your health, like how old are you? Normally, if you are like 80 years old, you are likely to be, that's a negative weighted factor, because you are more likely to become a public charge. Health, if you don't have good health, you are more likely to become a public charge. What's your family status? How many assets you have? What resources you have? Education. The lower the level of your education, of course, you're likely to become a public charge. What skills? If you have very high skills, very high in demand, you are not likely to become a public charge. So they'll look at all these things together to determine not only your long-term institutionalization or the receipt of public cash assistance for income maintenance. Okay. Now, what if a non-citizen receives a public benefit while in a category that is exempt from public charge ground of inadmissibility, but then applies to adjust status while in a non-exempt category? So what this means is that U.S.A does not consider so for example, well, let me explain it first, then we'll give the example. So U.S.A does not consider any public benefits received by a non-citizen during the period in which the non-citizen was present in a category that's exempt from the public charge inadmissibility test. So for example, as if you're an asylee, like you're applying for asylum, or even you're applying for VAWA as an abuse, for example, as an abused spouse of a US citizen, the public charge rule of inadmissibility does not apply to you. Now, if you switch status, like now you are no longer applying under that. So you were applying for VAWA or as an asylee, or you were applying for asylum, and you took these benefits like public, public cash assistance for income maintenance or long-term socialization, and then you no longer are applying under that category, and you now want to apply under a normal adjustment of status, green card holder, through the normal route. Will this affect you? Will this affect you? And they're saying no, they will not consider any public benefit that you received at the time you were exempt. If at the time you were exempt, you receive these benefits, it doesn't count against you. Don't worry. All things are passed away. The old things are past. New things are new. So once you now move from that exempt status, the public benefits you received at that time will not count against you. Okay. So they'll stick to their word. If you were in an exempt category, you continue to be exempt. Despite the fact that you received those benefits the time you were exempt. Okay. So okay, so let me see. I was a little distracted. Okay. So, for example, an individual with refugee status is exempt from the public charge ground of inadmissibility and may be eligible for a range of public benefits, including public cash assistance for income maintenance. If this individual later applied for adjustment of status based on family petition, you apply for asylum because you're being persecuted by your home country, and then you're in the US, and then you find a US citizen spouse, you fall in love with them, and they're now filing an I-130 for you, then you would be subject to the public charge determination, but your receipt in the past will not be considered the time you were exempt. Okay, I think that's clear enough. Now, COVID-19 issues. Will receiving free COVID-19 testing, vaccinations, or treatments be used in determining whether someone is likely to become a public charge? No, we do not consider public charge assistance for immunizations and for testing and treating communicable diseases. We do not consider receipt of Medicaid and other public health insurance and health services. Okay. So, and here's what the sweet news. We encourage everyone, regardless of immigration status, to receive their COVID-19 vaccine and subsequent booster vaccines. We also encourage everyone, including non-citizens with COVID-19 symptoms such as fever, cough, shortness of breath, to seek necessary medical treatment or preventive services. Okay. Those things will not count against you. Okay. What about other COVID-19 public assistance, such as for food, housing, cash assistance, rental assistance, tax credits, stimulus payments, unemployment, financial aid grants to students, paycheck protection, and student loan forgiveness, student loan forbearance? The answer is this: we do not consider such public assistance that is specifically related to COVID-19 because these are non-cash benefits or special purpose cash benefits that we do not use in making public charge determination as a general matter. We only consider supplemental security income, um, cash assistance under the TNF program, and general assistance. In other words, cash assistance provided by states or localities, as well as long-term institutionalization provided at government expense. Okay. So these are the things that we've discussed that count towards public charge, but not COVID-related benefits. States have flexibility in administering the TNF program and may choose to provide non-cash assistance such as subsidized childcare, transport vouchers, in addition to cash assistance. Such non-cash assistance such non-cash benefits are not considered for public charge purposes. States may also provide non-current cash payments for specific crisis situation under TNF. Okay, so that's it. Okay, I think we can do the affidavit of support in part 2 of this video. We'll continue with this discussion. Okay, all right, guys. So thank you so much for joining us. We'll do part 2 of the video. So be sure to hit that notification bell, subscribe to this channel so that you don't miss any of our content. Let me make a note of this and then I can, we'll be sure to remember that the part 2 will cover the affidavit of support discussion, I believe from page 11 of this document released by U.S.A. All right, guys, thanks a lot for joining. Drop your questions and comments in, under this video, and then hopefully we'll be able to respond to you in subsequent videos. All the best, guys. I hope you're enjoying the holidays so far and gearing up for the new year. I really wish you a great finish the rest of the year, and hopefully we'll connect again soon. Take care and have a wonderful day. Bye.